Hi guys. I think it was maybe in one of my introductory videos. I only have one. I might have mentioned it in another. That I have quite a few backlogged reviews that I have written out, but that I haven't actually made a video of and posted on YouTube. And then I'm slowly in the process of trying to do that. This is one of those books. One of the ones that I read this year, but never really made a YouTube video of. It's a book by Justice Stephen Breyer, who sits on the Supreme Court. It's called Making Our Democracy Work, A Judge's View. This book is aimed at the non-specialist, and Breyer does a really good job at using some of the more important court cases in the history of the Supreme Court to take an opportunity to sketch out his personal view and interpretation of the Constitution. And then he discusses these cases in relation to how he formed what he would probably call a moderate, consequentialist, pragmatic approach to interpreting the Constitution and various statutory language. Part one of the book considers how the Constitution can ensure a workable democracy while at the same time maintaining its legitimizing power. More to the point, he asks, why should a democracy, a political system based on representation and accountability, entrust the final or near final making of such highly significant decisions to judges who were unelected, independent, and insulated from direct impact of public opinion? And that's really an interesting question, especially, in the age of, in the past 12 years, we've already had the Supreme Court basically decide a presidential election, and a lot of people who study the federal court system have said, perhaps understandably, that decision, and it's not a political observation at all. It could have gone for Gore, did go for Bush, doesn't really matter. But when the court makes that decision instead of the Electoral College making that decision, or more indirectly, the people making that decision, that sort of saps away what Breyer calls the legitimizing power of the court. And it's an interesting question that keeps popping up again and again in the book. How were the courts legitimate? How do they practice that legitimacy? And that's a question that you don't often hear enunciated as often as I would like. Some of the cases Breyer looks at in Section 1 are, of course, the more well-known ones. Marbury versus Madison, the Cherokee Indian cases of the 1830s, Brown versus Board of Education, Dred Scott, Bush versus Gore, like I already mentioned, and uses these cases to show the growth of popular acceptance of court decisions, beginning with Jefferson's refusal to acknowledge Marbury's commission, to the seeming blanket acceptance of the fact that the Supreme Court chose the president 12 years ago. The chronological discussion smartly considers the changing contours of public opinion and describes how the court, an institution that began with almost no sense of judicial legitimacy, constructed it slowly over time. That Breyer considers the case of legitimacy first is telling, and I think very important and interesting, and it's obvious that Breyer knows that the court is powerless without this assumed legitimacy. Part 2 discusses some of the ways in which Justice Breyer believes the court has to maintain the public trust that it has earned and built. Here he spells out the differences he perceives between a textually based approach, which he argues against. This might be the originalist approach that you've heard it called, the approach of what some people would consider the far right of the court, like Scalia or Thomas, and maybe even a couple of others, but certainly those. And in its place, he argues for what he calls a purposes and consequences approach. The former, as I said, is roughly equivalent to an unchanging ahistorical originalism. what they wrote is what they meant, and that's how we must read it. That sort of approach. On the order of, like I said, what Justice Scalia argues for. While his purposes and consequences approach is something more like what we call a living constitution or a living document or an organic document. Here he talks about the role of federalism and the roles and specialties of other courts and the function of stare decisis. Part 3 talks about individual liberties, especially the cases coming out of the Japanese-American cases in World War II, like Korematsu and Hirabayashi, and the executive power and accountability, like we see in the terrorism cases, Rasul, Hamdi, Hamdan, and Boumediene. For someone who might be familiar with the history of jurisprudence discussed above, as any law school grad probably would be, the historical parts of this book will already be really familiar. And while I'm not an attorney myself, I had the pleasure of discussing this book with my partner, who is one, which made reading it and talking about it all the more enlightening and the source of a lot of exciting discussion between us. I'd always admired Breyer's moderate, pragmatic, decision-making approach, and anyone who wants an insight into that angle of interpretation into the Constitution is I think, going to be in for a treat if you want to read this book. It's a really good synthesis of history and opinion that gives a lot of insight into Breyer's approach, and will shed some light on Breyer's hermeneutic decisions for even those less familiar with the case law. But an interesting book, and certainly one that tells you a lot about how Justice Breyer thinks and approaches cases. Making Our Democracy Work, A Judge's View by Stephen Breyer.